Hi, everyone. I see the numbers are steadily climbing as participants join us. Welcome back to Thomson Rogers webinar series. We hope you all had a great summer. We certainly wish that we were all together in person, but for now, Zoom will have to do. And after taking a summer break, we're back today, and it's actually the first National Day of Truth and Reconciliation. Thomson Rogers has a strong connection to Indigenous and First Nations communities, and my colleague Darcy Merkur will elaborate on that in a few seconds. For those of you who don't know me, my name is Ava Williams, and I'm an associate here at TR. I practice primarily personal injury. I work with victims of car accidents, folks with traumatic brain injuries, and I also do a little bit of civil litigation of sexual assault. So today I'll be presenting alongside Darcy on a hot topic, which is handling difficult clients. And I'll turn it over to Darcy.
Morning, everyone. So we're here today to talk about handling difficult clients. Why am I the one presenting it? Well, it happens to be National Truth and Reconciliation Day. I had the privilege of working for the first almost 10 years of my career on what was then called the Aboriginal Residential School Class Action Settlement. We represented Mr. Baxter, who initiated the national class action. Through the course of that, I attended every settlement meeting, every discussion, was at many residential schools, flew across the country, participated in all the discussions. So I'm quite familiar with the topic. Also, in the course of the residential school claim, Thomson Rogers had the privilege of representing hundreds of victims of the process. I did dozens and dozens of hearings myself, and in the course of that, I got some experience dealing with handling clients who were somewhat difficult for understandable reasons. For example, in the context of the residential school claims, there was a major distrust of authority figures like lawyers. There were trauma impacts from history of sexual abuse. There were substance abuse issues that were front and center. There were progressive disclosure issues, which you see in car accident cases in the context of brain injuries a lot, that had to be explained and understood. And one of the things I found interesting was you had a limited time to build that trust. I only got to meet these clients a few times. They're far in remote communities and they're hard to reach. But handling them when you just got to know them was very challenging, and I got some experience doing that. And you guys have to deal with that as well from time to time. The other reason I think I'm well suited to address the topic of handling difficult clients is I'm a brain injury specialist, certified brain injury specialist by the Brain Injury Association of America. I'm the only lawyer in Canada with that designation. A lot of providers have it. I've been helping accident victims for over 20 years. I take a lot of pride in being responsive and staying in touch with my clients, including post-accident. So I keep in touch with clients I represented years ago, and it warms my heart to know how well they're doing. Our topic today is, I think, Ava, you have something to add there before I go on?
Yeah, so we just want everyone to stick around because we are actually doing a draw at the end of the seminar for a $50 gift card. So stand by.
So our topic is handling difficult clients. And I'm going to start off by just talking about the basics from a legal perspective. You're all pros at handling difficult clients, and that's not what this seminar is about. This seminar is about handling difficult clients in the context of a legal process, which is a big distinction. You're trained, experienced, educated on how to help somebody who's making it difficult to be helped. But where you may have not been trained is how to deal with that in the context of a legal process. So there are some major differences associated with the people I help than the people that you necessarily help. The people I help are typically people injured from a traumatic event, often a car accident, for example, where you may be treating somebody who just had a fall, nobody to sue, just one-on-one treatment. The differences in the context where I'm involved are threefold. Number one, when it comes to accident benefits in car accident cases, there's an insurer. Insurer approves the treatment, approves further treatment, receives progress reports, and you're reporting everything that's done to an insurer. You still represent the client, you're still helping the client, but the privacy is not the same as a one-on-one private retained situation. Number two, there's a lawyer, there's me. I'm in the backdrop. I can be relied on anytime for help managing any situation, which isn't the same in a private setting. And number three, which is the highlight and focus of this discussion, along with the legal aspect, is that there's a rehab team that's assembled, that's there to assist in handling these difficult situations, where that's quite different than a one-on-one situation. So while you're experts at dealing with it on a one-on-one clinical setting, you may not be experienced or well-trained at dealing with it in a comprehensive legal process setting. We're here to just emphasize some of those distinguishing features and how we can help solve the problem. And what we're going to focus on are three different types of difficult clients that we see in the context of litigation. One is clients resisting treatment and care. Two is clients misreporting information to you and others in the course of our litigation process. And if you have ideas about things that you see that people misrepresent, throw those into the chat and we'll try to address them later. And the third one is clients and self-harm and issues of suicide and self-harm initiatives. And before we talk about how to handle those difficult situations, let's just revisit the legal perspective and just emphasize what we're focused on. So our goals are recovery and compensation. That seems to be consistent with the client's goals because that's our job, is to represent the client. And what they typically want is, I want to make a great recovery and I want to get as much money as possible. The rehab team is focused exclusively on the first issue, which is helping them make a great recovery. But the significant compensation aspect cannot be forgotten. And when we talk about solutions, we're going to emphasize that you need to be mindful of the legal impacts of how you handle any situations with difficult clients. So just to focus for a second on how we achieve those goals. Number one, when it comes to a great recovery, what we do is we help assemble a team of exceptional rehabilitation providers, all of you. And we ask you to help, and we know you'll put your devoted, experienced, wonderful services to help the person with a great recovery. But that also includes expanding the team as necessary to bring in new people, new disciplines as appropriate. And where we really come in is to secure funding for everything the person needs. Insurers have to pay, but they have to be convinced to pay in some circumstances. And Ava and I spend a lot of time pushing the insurers to do the right thing and fund all of the treatment. Also, when it comes to compensation, what we're looking for and what we have to do is to prove that the person we represent has accident-related injuries, needs, and damages. And we do that by expert reports and treatment reports to prove that the complaints they have are indeed from the accident, that they have needs that they're accessing, and that they've suffered as a result, they're struggling returning to work, etc. And what some providers may not appreciate is that the only way we achieve a good result for somebody and get them maximum compensation is by threatening the possibility of getting a wonderful trial result. That is the only way I can ever force a responsible insurer to pay in the context of a lawsuit. In the context of a benefit claim, it's a little bit different because they have no obligation to ever settle. But in the context of a lawsuit, we need to threaten the possibility of getting a judge or jury to give you a great result. Now, in the context of car cases, every single car case involves a jury because the defendants insist on them. They know juries are unpredictable and often cheap in Toronto. So they always serve a jury notice almost in every case, except maybe a case where the defendant's convicted of drunk driving or something where they have reprehensible conduct. But to get that favorable trial outcome and to threaten it with a lot of force, we need our clients to be honest, likable ideally, and must show effort. They must try. If they don't, that's where we want to run into trouble. So where you can help us with our goals is to help us prove that our client's honest, which we're going to talk about, and that they're giving maximum effort. I'm going to turn it over to Ava to talk about some other issues. But before I do, the key takeaways are that you're pros at managing the situation, that you have to do so in the context of a rehab team and a legal team. And you must be mindful of the legal background when you're handling these cases and how it may impact those issues of both recovery and compensation. Ava?
Thanks, Darcy. So here's a sample list of types of difficult clients that we may all encounter in our day-to-day jobs. And I'm actually really interested to hear from you if there's any other types of difficult clients that you encounter or ones that you feel as though don't fit these 5 categories. And of course, today we're focusing on 3 types of difficult clients. And by difficult, I should say we mean challenging. But I think it's important to note that most of our clients in the context of personal injury litigation do have complex diagnoses. It's quite rare that there's one standalone injury, and that's why it's important to have a strong treatment provider team in place to ensure that our clients are getting all of the treatment and care that they need. And as treatment providers, you may encounter clients that lack boundaries. They may call you at every hour of the day. They may call you outside of appointment times. And that can be quite stressful for treatment providers. And I think where Darcy and I and other lawyers at TR can come in is we can be the quote unquote bad guy and say, whether it's on the team meeting or one-on-one with our client, listen, you need to, respect your treatment times. How can we help you if you feel like you need more support? And because you're not alone in this, we don't want you as treatment providers to feel like you have to shoulder the burden that comes with particularly challenging clients. And to that point, the American Psychological Association, again, this is just a sample list that the APA suggests for coping with challenging clients. And I think it is really important to approach these clients from a place of empathy, especially as lawyers. And I think, Darcy has wonderful experience, as he mentioned before, and so do I in different aspects, that we do approach our clients with empathy. And we try and understand where they're coming from while working towards those goals of compensation and recovery. And again, seeking support from your peers is so important. Again, you're not alone in this. And Darcy and I are your peers. We can work with you in managing these clients and again, achieving those objectives. And here are some tips from the occupational therapy perspective. And I think the focus on why the treatment is helpful is an interesting consideration. So you as treatment providers, you can speak to the actual impacts of the treatment on the person's everyday life. They can walk more, they can go to the washroom on their own, they can do their own personal care. However, if you're experiencing clients who are resistant to treatment, Darcy and I, the lawyers, can speak to a different side of why the treatment or the therapy is helpful. And that goes to the lawsuit itself. Again, showing that the car accident, the incident has caused injuries and caused a need for care ends up in achieving the objective of compensation. And when a client understands it in that perspective, they may be a little bit more willing to cooperate. And now I'll turn it back to Darcy. We do have a few chats. So clients who report incorrectly on lawyers advising them not to return to work. I think Darcy's going to speak about misreporting. Clients who are angry and threaten to go to the provider's colleges. I think, that's quite difficult, and that may be helpful point where Darcy and I can jump in and really be, again, the bad guy and trying and get them to reason with the fact that you're just doing your job and we will support you in doing your job. And if you do have to report certain ethical obligations to the college, we will support you again.
And I'll try to address those when I get to the next slide in a second. But thanks for pointing those out because I'm not monitoring the chat right now. I'm going to talk about the first types of client problems we see and difficulties we have handling clients. That's clients who resist treatment and care. I find that I see this all the time. And again, having regard to the legal backdrop of both recovery and compensation, this issue causes me the most concern because resisting treatment hurts recovery, hurts my effort issue when it comes to threatening a good outcome at trial, and hurts the value of the case because they're not accessing expenses at an insurer's expense, so that when I argue later that they have a lifetime of expensive needs, I get laughed at because they're not actually accessing them, and nobody believes they'll have long-term access, that they would actually use the money. So it makes it very difficult on me. So it's an area that we all need to do better. And the first point is understanding why. And you guys all know this, but we all need to understand why it is. And where it gets challenging is it may be difficult for the physiotherapist to understand why the brain injury is interfering with their ability to initiate, for example. And I know the physiotherapists are well trained and they get it. But my point is, outside your discipline, you may be dealing with issues that you're not trained on, that you're not experienced in, that are beyond the scope of your primary expertise. So the things we see are privacy intrusions, where the client has hidden habits. They don't want people in their home finding out about what they're doing in their spare time, or their wife or their kids or whomever. Denial issues, you see that a lot with teenagers and younger adults and people in the workforce and parents. They just don't want to believe that they're injured and they can't go on with life as they expected. So they just deny that they're injured and try to get on with it, go back to work. Brain injury impacts, fatigue and confusion. They just can't remember these appointments. They're just too tired for them. So they give crappy explanations for why they can't participate, when it's really just fatigue and brain injury sequelae. Mental health issues, depression, sadness, inability to get your next issue, get off the ground and get ready to do the next task and next form of therapy. And financial concerns. The costs are mounting up. I only have 65 grand in this non-catastrophic category. I'm worried about what's going to happen with my life, my inability to work and earn. So those are the type of issues we see, and it's important to try to understand why. And the answer is to collaborate as a team and figure out why. So of course you should acknowledge their concerns about, the financial impacts, for example, and you have to build trust gradually. As I mentioned, the residential school example, I just don't show up and they say he's a lawyer, I trust him. It takes a lot of time, and that's understandable, and it should be. You need to educate them and their inner circle about the impacts of their injuries and how it may affect their willingness to participate in treatment and care as best as you're allowed, subject to privacy rules, of course. And you need to loop in the lawyer. Here's where I come in, and I explain to the client, hey, you're not doing yourself any favors here. Our goals are recovery and compensation. To help you make a recovery, I need you to access treatment that's recommended. To help me get you the most compensation, I need to show effort and a spend rate to justify your long-term needs. If you don't do that, don't expect me to get a good result. You hired me because you know I can get you a good result. Don't handcuff me by resisting treatment and care. Moreover, in any lawsuit, every defendant puts in their little statement of defense that they're going to argue that the injured person failed to mitigate their damages, failed to do everything reasonably necessary to get back on their feet. So they're going to face the argument from the lawyer. And I don't want that lawyer to be able to say, you see, when that doctor recommended getting a vocational assistance and the client rejected it, that's why they can't work. I don't want that to happen. I want them to try everything that's recommended. If they fail, so be it. But they have to show effort. They have to show that they've tried to mitigate. But the key to managing and how to manage these situations where a person resists treatment and care is to loop the lawyer and the team in, coordinate the team meetings. With the COVID dynamics, team meetings are easy. I don't need everyone to travel 2 hours to show up in Bowmanville for a team meeting. We can all get on Zoom almost on short notice and discuss the situation with the client, with their immediate family, with their permission, and talk about the issues and address the issues of their failure to participate in treatment and care and the impacts, and understand why, so that everyone can share what they know with the person's permission. They're in the room and you can seek permission before, and I'm going to have to talk about that thing you didn't want anyone to know about, that privacy thing. Is that okay? And they'll say, okay, they understand, and solve the problem. I have a client right now at a rehab hospital, for example, and the advice from the rehab hospital was stay here until October 8th. And the client, who's youngish, 20 or so, called and said, hey, I am getting out of here October 2nd. This is ridiculous. I've been here too long. And I spoke to him and his mother with his permission. And I said, it's not the right advice. You've got documentation that says you should be there until October 8th. You've got limits that can be available to help you privately afterwards because you're in the non-catastrophic category. Stay there. Let OHIP pay for your bills. And Of course, they followed my advice because I've got experience. I understand the issues. We have the same goals, so they're on the same page. So I talked them off the ledge on that issue, and they complied. Another big issue, misreporting. This drives us as lawyers crazy because we can't control what ends up in your records. Clients misreport things all the time, especially when you're dealing with brain injuries. They get things wrong. They do some for some reasons, and they do some for other reasons. And the first question is why? Is it health reasons? Is it the brain injury? Or are they scheming? Do they think by saying they're not working, their lawyer and the team's going to be able to get them more money? And if so, loop me into that concern so I can speak to them about the importance of reporting things accurately. So I would educate them on the consequences, as can you, that, hey, my reports are going to the insurance company. If you tell me you're not working and I have to report you're not working, and if they catch you working with the surveillance, or if you tell other providers something different, or you show up after work, there's going to be consequences. The insurance company is going to make it more difficult for you. They're going to send you to more assessments. They're going to cut you off benefits. It's going to impact your lawsuit. And let me call Darcy or Ava and have them talk to you about the consequences and the importance. So loop me in. I would explain what can go wrong if they misrepresent something. It's usually something silly too. And I'm sure you have some examples there about what the misreport. The typical ones I see is their ability to work, their ability to do housekeeping, their use of alcohol, their ability to drive. I don't want those things wrong. If they're driving, I'd prefer to tell them why they shouldn't drive or get medical clearance so they can drive legally and be open book about it. If they're doing their own garbage in the mornings, I prefer that to show up, and then I can't do my own garbage and that get into the OT's report and cause me trouble later when it's caught on surveillance. But use team meetings to unearth these inaccuracies. So if you're suspicious of what they can and can't do, let's get to a team meeting. Let's talk about it. What are the things, James, you can do around the house these days? Because we're a little confused. Oh, I can do this. And then the OT, well, didn't you do that? Okay. And then everyone's on the same page. Everyone's notes are consistent. Collaborate. And that's the emphasis of our comments on this topic when you have clients misreporting. Collaborate, loop in the lawyer, avoid having it show up in your records wherever possible, because you unearth the correct information before it gets misreported and causes us difficulty.
All right, so I'm going to speak a little bit about clients in distress. And this is something that I see in my practice, but it's also something I have experience with as a crisis line worker. When I was in law school, I volunteered with the Sexual Assault Center London, and I would work shifts of handling the crisis line. And that actually required months of training. And I feel like it's really shaped who I am as a lawyer and shaped how I approach my files. But, you know, I'm sure you see it all the time. We see it all the time too. Trauma can be physical, it can be psychological, it can be emotional. These clients are coming to us and often the worst time of their life, and they don't know what to do. They don't know what's going on. It can be very distressing for these clients. And unfortunately, the legal proceedings are inherently stressful. They're inherently triggering. I mean, I see it in clients after they've gone to discovery, or after they've gone to a defense medical or IE, or there's been an unsuccessful mediation. These are all important parts of litigation, but they're also parts that can really make the client feel like they're not being believed, or that their pain, their injuries aren't real. And it can be so upsetting. It can be, earth-shattering for these clients. And I think we as lawyers can do a better job at understanding the specific points in the legal proceedings that can be triggering, maybe handling that in a different way than we normally do, but also looping treatment providers into the mix, letting you know when these events are happening, and perhaps facilitating or setting up appointments before, during, or after these events are happening. And again, the care that the clients are receiving is not siloed. You're not alone. We want to help, and the beauty of having a wonderful treatment team is that we can all work together and, ensure that the client isn't in distress for long, or that, they don't actually commit suicide or self-harm. And I think that it's important also to document this distress. There's a lot of shame and taboo around self-harm and around suicide. And it may be some of our first responses not to really go into depth or go into detail when we're reporting on this in our notes. And, it can actually be quite helpful to a client's case in reaching that objective of compensation. And, as long as the notes reflect that the distress, the suicidality, the self-harm is causally related to the car accident or, the abuse that's happened. These are tangible, concrete things that Darcy and I can go to the insurer and say, look, this person has gone through this trauma that you are responsible for. They need this care, they need this help. And, mental health care is ongoing. This is something that if it's documented properly, we can convince the insurers that this person will probably need it the remainder of their life.
Yeah, and I'm just going to jump in on that point because I find that providers, they often call me to say, this person's talking about self-harm stuff, what should I do? And my answer is always the same, is, do you think it's related to the accident? Of course, you got so many, of course. Well, then document it and make sure it's well reported, because it'll justify 24-hour attendant care. It'll help my lawsuit, it'll help the client's recovery. The instincts are always to sort of downplay it. And in so much as it's completely unrelated to the accident, the unrelated cancer diagnosis perhaps, then maybe. But typically you see a complete relationship between the accident and the impact it's had on their structure and their life and their feelings. So documented well, it's the best thing I can have to achieve my goals. My second goal of compensation is by referencing that as a reality that's causally related, that's well documented.
Good points. And happy to take questions and answers if anyone has any. There's some resources on here, and I think we'll circulate the slides to all participants after, but these are great resources that have to do with mental health and distress. So I'm not seeing any. Oh,
go ahead. If
Darcy,
there's any questions, just raise them if you don't mind. I'm going to start concluding, but if there are some questions, okay. So our key points for this message, our takeaways are: you're not alone. It's very different than your individual, isolated, siloed practices. This is typically a team-oriented situation with a legal backdrop. So in the context of those legal teams, rely on the trauma lawyers and the rehab teams as a group to collaborate and come up with smart solutions to handle difficulties with accessing treatment, suicidal ideation, self-harm, and misreporting dynamics. And use these team meetings to collaborate, come up with solutions that are enforced, that are consistently adhered to. And we're very approachable. I know I am, I know Ava is. Contact us, keep us in the loop. We can weigh in. We have a lot of sway with our clients. Believe it or not, some of them actually like me. And not always forever, but we're there to help them, and we really take a lot of pride in it. And as I mentioned at the outset, I keep in touch with a lot of them because I really have learned a lot as a person, and I really respect what they've done to get back on their feet, and it gives me a lot of joy to see them get on with life, especially over the social media, etc., on LinkedIn. Ava, you want to just wrap it up?
Yeah, so I will do the draw right now. And I will pick a number, and Darcy will read the name that corresponds. We do have a couple of questions.
Good, because I don't have the list of names in front of me.
It's
But go ahead.
Okay. Well, we do have a couple of questions. I know we're running out of time. There's one from a caregiver, as a client, who's the best person to talk to about these issues to be documented? And that's the treatment providers, I would say. Right?
Yeah.
Okay.
Social workers, psychologists,
Yeah.
anyone who's
Yeah.
dealing with the mental health aspects.
All right. So
Okay, do the draw, but we're gonna have to, unless Elise is on the line and can jump in, we're gonna have to announce the winner later because I left the answer sheet.
okay. So number 39.
Okay, and we'll be in touch with the winner
We'll be in
after.
touch.
Thank you very much
Thank
for
you so
participating.
much.
If there are any follow-up questions, feel free to call or email us anytime. We're here to help. 39, and I do have the winner list here. 39 is Alana McIntyre.
Yay.
Wow, congratulations. I know she happens to be in town, so we can make sure it gets in your hands.
Congrats, Alana. Bye, everyone, and we'll see you at the next webinar session on October 28th. Thanks.